note from the filing department, Lord.
This is what is normally done. When one matter relates to life or something where lordship will hear, the other analogous matters also are listed along with that.
Yes.
Yeah, otherwise there will be a conflicting, maybe conflicting views, because if your lordship says that PW1 is not reliable, single bench may say that he is reliable, then it will get conflicting views, lordship.
So you don't want it today.
Yes, Lordship. Accommodation for today.
In
As
item
in,
number 10 and 8 will may be taken up, lordship, because I have filed one application for bail that is pending, lordship.
Item number
8, lordship. That may be taken up today. Otherwise, his matter also is not, his eye is already disposed of. So he will not get prejudice, lordship.
okay, wait for some time.
May it please your lordship. Lordship, I beg to mention item 14 to be adjourned for the day, lordship.
Mention slip is there? No mention slip.
Mentions it. Lordship, due to some difficulties today, my senior
Who's your senior?
M. Datta.
On request made on behalf of Mr. M. Datta, Leonard Amicus Curie, list the matter after 3 weeks.
Of like
May please, your Lordship.
Um,
Lordship, I beg to mention item number 15 of daily causeless service.
Yes,
Sir, the conducting counsel's father-in-law expired 2 days back, Lordship. So it is not available today. Only maybe.
you also mention slip, is no mention.
Yes, I have given that.
Have you given that?
Yes. No, I have given the adjournment request, Your Lordship.
You've given your adjournment request.
Yeah.
Was it consented?
Yes, consented
Who
yesterday,
signed
my Lordship.
Who signed it? You've given consent. Yesterday they took my signature, yes.
Okay.
Item number?
15.
15.
Okay,
It's
you are appealing on behalf of,
T. Kolita, Your Lordship.
on request made on behalf of P.
Yeah.
Kalita, Leonard counsel for the applicant. List after 3 weeks. 3 weeks?
Yes.
Yeah.
Much obliged, Your Lordship.
Item 1 for
May I please, your lordship? This criminal appeal is preferred by the appellant being highly aggrieved and dissatisfied with the impugned judgment and order of sentence passed by Sessions Court of Majuli.
Under section
Convicting under
302.
section 302 IPC
that.
and sentenced to suffer rigorous imprisonment for life.
Okay. Third MS. And
M.
also
Hassan.
other counsel for the applicant. Okay.
I have an IA also, Your Honor.
Yes. MSS Jahan and additional PSR. Appears on behalf of the respond number 1. Applicant to take steps for service of notice on respond number 2 by registered post 80. Within 1 week,
I have an IA also, Your Honor.
within 1 week, we'll take steps.
Any
Respond
being
number
appealed.
Stop. List of matter after 4 weeks. If I. And Hassan doesn't counsel for the applicant. Issue notice. MSS Jahan, Leonard, additional PP. Grace for how much
2
time?
weeks.
2 weeks time to file objections. Where is allowed? Applicant to take steps for service of notice on respond number 2. By registered post 80 within 1. This after 4 weeks.
So 2 is also heard. Item 2 is.
Item 2.
Yes.
May I please your lordship.
J.
Lordship against judgment is appeal is lordship against the judgment dated lordship 27/3/2023. Whereby lordship is petitioner will be convicted of imprisonment for life lordship. Under section 6 of POCSO Act.
You are Mr.
J. Kolita.
Head J. Kalita, Leonard counsel for the applicant. Admit conference, yes. MSS Jahan and additional PP. Assam. Appears for the. Respond number 1. Appellant to take steps for service of notice on respond number 2 by registered post ID within 1 week. List after 4 weeks. In the IA, at J. Kalita, then counsel for the applicant. Issue notice. Ms. S. Jahan, then additional PPR sample appearing for respond number 1. Phase 4, 2 weeks time
Yes.
to file objections. Prayers allowed. Applicant to take steps for service of notice on respond number 2 by registered post AD within 1 week.
Lordship.
List after 4 weeks.
Obliged.
Item 3.
Yeah, please, Lord. Look, this is against the judgment dated 8/2/2023. My lord, I have come before Lordships,
Again, 302 matter.
and there is a 302.
But BJ3 then a counsel for the applicant, appellant. Let me call for NCS. MSS Jahan, additional PPR sum appears for respond number 1. Appellant to take steps for service of notice on respond number 2 by registered post within 1 week. List after 4 weeks. DIA, but BJ3. The same order.
Lordship.
The IA will be pressed, my lord, after receipt of the LCR. Lord.
And I'll file my objection in the meantime.
Item 4.
My lord, 302, conviction for life. So
Yeah, Mr.
TH Hazarika.
TH Hazarika and counsel for the appellant. It meet calls for NCS. MS S. Jahan and an additional PPR sum appears for the respondent number 1. Appellant to take steps, same order. IA also same order.
Yes, deeply obliged. my lord.
For orders, item 5, 6, and 7.
Item number 5 and 6, in fact, it was heard in, the IA was heard in, it was rejected.
Lordship, we have taken steps on 3rd Lordship March 2023. There is office note in item number Lordship 98, item number 5. We have. created this, हमारे तो दिया नहीं. Definitely issue.
I think item number 7, IA is pending. But
You've taken wrong steps.
Lordship.
Who is the supplementary file? IA was rejected.
the item number 5 and 6 IAs were rejected, 7 it's pending. No, I mean, 6, 5, 6, and yes, 7 is pending. In fact, 7 was also taken up on the last occasion. There was some mistake with the name of the applicant. That is what he had shown from the records. And then I think it was kept pending and it was not disposed of.
Not this.
But it was heard at length at one point of time. Abidur Rahman. It was a mob attack and number of them were convicted.
You are appearing in which matters?
Lordship, I am in item number 7, Lordship. We have taken steps, Lordship. If there is any defect, Lordship, we may be allowed to take fresh step.
And how about item 5 and 6?
5 and 6, I am appearing.
Have you taken steps? You have not taken steps.
Within today, Lordship, I will take steps.
In the causeless, respondent is not shown, only state of Assam is shown. Acha, maybe there is
No,
something.
there was no notice. I mean, steps were not, wrong steps were taken.
Ah.
So the registry could not take steps. Okay. In item 5, write separate orders. Mr. A. Ahmad, learned accounts for the appellant. Prays for 1 week time to take first steps for service of notice on respondent number 2, isn't it?
Respondent number 2.
By registered post AD within 1 week from today. Stop. Praise allowed. List the matter up to 4 weeks. Same order in item number 6.
And one thing also, here there was a direction to the registry to prepare the paper book. That may be directed to expedite. Lordship.
Is it
Oh.
probably for that?
Registry is also directed to, registry is also reminded to prepare the paper book in the meantime. Is the matter of the progress. Same order in item number 6.
Mm.
And in item 7, you say Mr. L.R. Mazumdar, counsel for the appellant is permitted to take steps, first steps for service of notice on the respondent
Number 2.
by registered post AD within 1 week. Registry is also reminded, registry is also reminded to prepare the paper. List the matter of the progress.
Like
It's up to 8, no?
Item 8, 9 and 10.
Here in this case, Lordship, the IA is pending for where I have paid for suspension of sentence and release of the appellant on bail, Lordship. Here, Lordship may kindly take up the appeal memo, Lordship.
Appeal memo, criminal appeals, 200.
Lordship.
Yes.
And judgment, your Lordship will find page 14. Here what happened, Lordship, the son of the informant, he was missing along with his Indica vehicle.
Page,
Page 14, Lordship.
page 14.
14 of appeal memo.
Okay, yes. That is the judgment.
That is the judgment, Lordship.
Oh,
And here your Lordship will find that 5 persons are named here. And I'm Ibrahim Ali, that is accused number 3.
Yeah.
And background of the case is that the son of the informant was missing along with the vehicle. Thereafter, Lordship, FIR was lodged, and after 2 months of the incident, the dead body of the victim was recovered. And here your Lordship will find that 2 persons, one Molo Das and another person was absconding. Molo Das was killed in an encounter, Lordship. And from the record, what I find, the prosecution witnesses say that Molo Das confessed that he killed the deceased. That is in the record. And now my linkage with that Molo Das was found established by the prosecution through 161 statement of Molo Das, which in my humble submission cannot be taken into consideration, which is stated before police and that was not produced before the court. That cannot be taken as an example, linkage, Lordship. That your Lordship will find page 44, Lordship may kindly say, the reasoning of the learned trial court. Page 44. It starts from page paragraph 37. May I read, Lordship? This is the from here the reasoning why I am convicted. It is there, Lordship. Paragraph 37. For answering this question, let us now discuss evidence on record more to find out the answers of these 2 questions so as to fasten the criminal liability, if any, of the accused persons. It may be mentioned here that as per evidence of PW1, accused Molo Das and another person who was present with him at the time of incident had died. while one more accused still absconding. So here also my name is not there. Witness Mohammad Intazul Haq deposed that his younger brother, since deceased, went out from Gulaghat town for hire purpose along with his Indica vehicle bearing registration number so and so. But he did not return. So they came to police station and informed the matter. He also corroborated the evidence of PW1 by deposing that while searching the culprits responsible
But
for the
Mr.
incident.
Ahmed, on the basis of this judgment, we can't give a decision. We have to look into the facts.
So this is the finding, Lordship, from the evidence what it is there. The learned trial court has mentioned here. Therefore, I am placing. And if your Lordship see that paragraph 47, this is the only linkage between the deceased accused Molodas and the present appellant. That cannot be the basis of conviction, Lordship. And if that cannot be basis of conviction, that I have a ground for bail, Lordship. Paragraph 47, Lordship may kindly say. Apart from that, there is no material on record. This is a case of no evidence, Lordship.
If I may,
Whatever that
my lordship,
co-accused has
if your
stated
lordship
before.
takes it up on Monday, because today I have filed my written objection, but today I don't have the copy with me. So if it can be taken up on Monday, because what he is placing, Molodas is the prime accused. He was caught. But then he took the name of the other person. I'll have to check to what extent.
That is before 161, and that is bar for under evidence act, Lordship. The 24 that will go.
Monday, lordship will take it up. I'll submit.
Okay, in the I heard Ahmed, learned counsel for the applicant. On the first, we don't have a best movement by is done and then we see. Monday will be difficult.
Any day at your lordship's convenience.
31st.
First,
That will be witnessed.
Obliged, Lordship.
Petition.
Item 11.
My lord, there is no aware of the facts and everything, my lord. I have given the copy last time. Your lordship said that order will be passed in presence of
I
the.
said, lordship. on the
No, no,
last
no, ma'am.
occasion,
What
we
lordship said
submission
that-
before his honorable court. If the document submitted by my learned friend, learned senior friend tallies with the whatever court observed that on that particular period, they have taken the daughter of the accused person to Kolkata, then I have no objection. If your lordship grants bail for a lordship limited period, lordship under the council appearing for the informant was not present, so lordship was pleased to fix the matter for today, your lordship.
Yes, informant.
Yes, I have gone through it, my lord. This document, this is with regard to 21/1/2021, my lord. Apollo Glean Eagles, my lord. And previously, yes, and previously, my lord, the document submitted before this honorable court, while previously granting extensions, my lord. There is a train ticket also of 16/6. On 19/6 and 21/6, there were appointments. So that is been telling, my lord. So what I am on, they have made a prayer for a long period of time, as if it's been going for vacation. That I have objections, my lord, to that extent, my lord. The girl
How
has,
much time you have prayed for?
My lord, I have prayed for 3 months, my lord.
No,
I don't know,
that
it may be less in the window. The moment it everything has happened, 2 months will be fair enough, my lord. I will come and submit the deposit the document with whom I have taken the treatment. Your lordship, I'll give a copy to him. He is very good to make some inquiry, my lord. He will make the inquiry and find that whether I have genuinely taken my daughter or not. Because we also don't want, my lord, the person saying lie will come out on bail.
only, my lord.
I'll go
respectful
give my
submission is
treatment, my
this.
lord, to my daughter, and I'll hand over the documents to the court for verification by my learned informant friend. And he will take all necessary steps to verify. And if anything wrong comes out, my lord, he will file a petition, my lord. I'll be taken immediately to custody.
What I
But
am
let
on,
me
my lord,
have a
with
chance to
regard
go and
to
take that.
giving an interim, my lord, that I have no objections because he has filed this document. Now with
That is
regard
what
to
I'm
the
asking.
extension, my lord, of
Interim 3 months.
3 months is a too long period, my lord. She is in Nagaon, my lord. Guwahati is 2.5 hours distance.
I'm
So
going to
1
Calcutta.
week would be sufficient, my. With all respect, my lord. 1 week would be
Well,
sufficient.
I'm going to Calcutta, my lord, with my daughter.
No, my
because
lord,
earlier
here
it
statement
was,
has been made.
my lord, earlier it was with the Calcutta doctors, my lord. I will first go to B. Borua as I have talked to the lady, my lord. B. Borua first will review it, then we'll make, my lord, necessary, or we may go directly to Calcutta. So give me the liberty to take my daughter wherever I
that
have to
cannot
give
be.
the good treatment, my lord.
And even
The
Calcutta, my lord,
informant
if your
party
lordship
cannot
see to
dictate
it.
the court, my lord, but to which doctor I should go approach, my lord.
No.
I have to save my child, my lord. It's
My
not
lord,
that with the life imprisonment, my every rights comes to an end, my lord. The daughter is innocent, my lord.
He's a
She is
convict, my lord.
helpless.
That
So
is
we
all
are
right, my
taking
lord.
her.
Last
for
occasion, my
treatment.
lord, they have taken time of, my lord, more than 6 months, it appears to be, with extensions. Now, my lord,
Yes,
the
granted.
document that has been submitted, let me submit. You have completed your submission, let me submit.
I'm not submitted
Yes.
on.
Then you complete it, Dada. What I am on, my lord, 16.6, you went for Calcutta with his minor daughter. 21.6, my lord, as per the document submitted, my lord. And thereafter, no other documents is there on record. So it took from 16.6 to 21.6.
Okay.
Whereas he was under bail for more than 9 months, whereas initially it was given for only a limited time. You know, it's extended, my lord. He's
Yes,
not
my-
a liberty, my lord, he's a convict. And
Oh.
that too under 302.
I have not extended, my lord. Court on seeing the documents and hearing the counsel has extended, even up to the Supreme Court, it was extended for the second time, my lord. It's not that on my asking only, I am doing everything, my lord. Courts are granting extension. I'm not taking extension on my own.
And whatever it has been submitted in the petition, my lord, in this particular petition, they have
Court
filed in,
after
my lord.
applying its judicious mind has granted the extension.
They intend to bring the girl to Guwahati for treatment.
Yes. 2 months will do, okay.
And my lord, 1 week time is sufficient, my lord.
1 week time, Mr. Fukan, let us be reasonable.
I leave it to your lordship discretion, my lord. That is my respectful submission.
3 months time is a little long.
My lord.
Too long, my lord, too long.
My lord, will
So
decide.
we are deciding that it should be 2 months.
My lord.
After expiry of that, he should surrender before.
Surrender, my lord.
And I take the undertaking, my lord, I'll this time surrender the documents also.
Third,
Yeah.
Mr. Z. Kamal, Learned Senior Counsel appearing for the applicant. Stop. Also heard MSB Buyan, Learned Edition Piti Assam. And Mr. A.K. Fukan, Learned Counsel for the respondent number.
Priya, my lord.
Oh, sorry, A.K.
No
Learned
issues,
Counsel
sir.
for the respond number 2. The applicant as applicant had filed criminal application C91 of 2019 challenging the judgment. Where's the judgment?
My lord, it's there.
Judgment dated
Yeah, my lord, I'm giving that.
28/8/2019.
Yes. Paper book is here.
Passed by the learned additional district and sessions judge. First track court, Hojai.
In session case number 59 of 2000.
Case number 59 of 2015. By which he was convicted and sentenced to undergo rigorous imprisonment for life under section 302 IPC, along with fine of rupees 40,000 and in default. To suffer simple imprisonment for 6 months. Stop. Para. The case of the applicant in the present application is that her daughter, that his daughter namely Priya De, who is aged about 13 years, is suffering from within inverted commas, you put non-Hodgkin's lymphoma. You will get it in page 12. Within brackets, lymphoma, oblique cancer, and is undergoing treatment in Dr. Bhubaneswar Barwa Cancer Institute, Guwahati. Stop. The applicant intends to take her daughter to Kolkata
Yes, my lord, for the better and
to
upward.
Kolkata for further treatment of his daughter. And therefore, the present application has been filed, praying for interim suspension of the sentence. Stop. Para. The petitioner and the applicant had earlier approached this court on several occasions.
Yes.
Where interim suspension of sentence was given from time to time. Stop. The last extension was given by the Honorable Supreme Court on 9/7/2021.
Yes.
Till 16/8/2021 and directed the applicant to surrender before the concerned jail authorities on 17/8/2021. Stop. Para. After hearing the parties, comma, and considering the welfare of the daughter of the applicant, considering the health, health condition of the daughter of the applicant, as well as her welfare, comma, we accordingly grant interim suspension of the sentence
For a period of.
with effect from, for a period of 2 months. With effect from today. Stop.
Not today, my lord, on coming out from the jail, my lord, because I don't know, my lord, how the order I will get sooner or later, my lord. From the date I come out, my lord,
From the date,
he is released from the jail.
from the date, the applicant is released from jail.
Jail.
Stop. Draft, comma, on expiry of
2 months.
2 months, he shall surrender himself to the concerned jail authorities forthwith. Stop.
One small prayer, my lord. In the criminal appeal, my lord, sentence has been already been suspended. Sentence and convictions are two different things. My lord, suspended. Here is a petition for only interim bail.
Yes,
For the purpose of, my lord.
Lordship has written date of it. Interim bail for a period of 2
Yes.
months, my lord.
Okay, interim bail. I'll come, interim bail. IAS accordingly allowed.
Because I'll surrender ultimately, my lord.
That order, my lord, he undertakes to surrender after 2 months. In
Yes,
That
sir.
I've passed.
Yes.
Already written, my lord.
Deeply,
And I will voluntarily give the copy to him so that, my lord, genuinely that he has done or not, he will verify. That will do, my lord. Much obliged. my lord.
Criminal appeal. Mr. Kama. Criminal appeal. We have not passed any orders.
I don't think in view of the order passed in this IA, my lord.
Hmm.
No order need to be passed, my lord. Because these are all tagged in matters, my lord.
Lordship, it's a criminal appeal of 2021.
IA has been disposed of.
Yes, ma'am. I will dispose of.
Criminal appeals, one order has to be passed.
Yes, but
But
it
then-
is for hearing, your Lordship.
Oh, you'll come up for hearing, ma'am.
21 paper book is ready, your Lordship.
You are appealing for the,
Be pulled, my lord.
hurt Mr. That command learned counsel for the
Yes, sir.
learned senior counsel
They are also for 2 and 2.
for the appellant number 1. Also heard MS B. Buyan, learned addition to Assam, and Mr. A.K. Buyan, learned counsel
For the,
for the
my lord, they also appear in the other appeal.
2 and 3, Lordship.
Item Guwahati 2 and 3.
you have Mr.
Appeal number 2 and 3, Lordship.
Your name?
Item number 1,
I,
IU Chaudhary.
item number 2 side, na.
I, U Chaudhary. For respondents, 2 and 3.
Item 10.
On top.
Item
Then
10, my lord.
appellants.
Item 10. Lordship. Item 10.
अरे भाई,
There are four appellants, your lordship.
ऐसा किन का item?
Item 10? Item 10 is not connected.
No, no, 11, your lordship, four appellants. For
Hmm.
one appellant, they have preferred the IA.
Mm.
Rest of the appellants are there.
Yes, so 2 and
Thank you,
3.
Lieutenant.
Are you just-
Item.
When shall we list this? Paper book is ready?
Yes,
Yes,
yes, your
ma'am.
lordship.
After?
After a month, my lord, after
List the matter after after 4 weeks.
4 weeks, much obliged.
Public.
Item 12.
May I please, your lordship? Lordship, we have filed an IA, lordship, for suspension of sentence, lordship, on the ground, on the medical ground, lordship. And to my information, lordship, on instruction from the appellant, lordship, he already recovered, lordship.
What is it?
He recovered, lordship,
Oh.
from his disease, lordship. So, lordship, IA is.
You're not pressing.
Lordship,
Your good name, please?
Ayu Chaudhary, lordship.
Mr. Ayu Chowdhury, learned counsel for the applicant. Submits that he has instructions not to press the present IA. Stop. MSB Buyan, learned additional PP appears on behalf of the respond number 1.
Lordship, yes.
IA is accordingly dismissed and withdraw.
Liberty may be given, lordship, if necessary, lordship, then file.
With liberty
To file a pet. If
to file a fresh. With liberty,
Lordship, here also paper book is ready, your lordship.
paper book ready.
paper book is ready.
Appeal of 2000.
Lordship, ready, lordship.
Criminal appeal,
Yes.
heard Mr. Ayu Chowdhury, learned counsel for the appellant. Also heard MSB Buyan, learned additional PP Assam. Paper book is ready, list the matter for hearing in civil courts.
Okay.
Obliged, lordship.
For hearing, item 13.
May it please your lordship. In this matter, my lord, that conviction is based upon on external. Extrajudicial confession, my lord. FIR it is page number 4 of the paper book, my lord. May I read, madam? My humble submission is that my brother-in-law, husband of the elder sister, Sri Suresh Chandra Rava, son of said late Thanku Roy, went missing from home on 23/7/2012. I could learn from a reliable source that the accused person named below had confessed before public that he, out of his personal grudge, had killed my brother-in-law in a planned manner and kept the body concealed by burying it in the hill of the Boyanguri village, part 2. And evidence are started from my lord PW1 at page 9. Informant is the PW1, my lord. In the year 2012, one of our co-villager, Suresh Chandra Rabha, went missing from our village. After few days, we came to know that accused had killed Suresh Chandra Rabha. Accordingly, a village meeting was called in which the accused admitted that he suspected Suresh Chandra Rabha of practicing witchcraft, and accordingly, he had murdered Suresh Chandra Rabha in the mountain. The accused himself led the police team to the place where the dead body was buried. The dead body was recovered. I lodged a FIR in this regard. Exhibit 1 is the FIR and Exhibit 11 is my signature. We had in cross, my lord, we had not informed the police when Suresh Chandra Rabha went missing. The FIR was lodged 1 week after the missing of Suresh Chandra Rabha.
It is not a fact that I have not mentioned in the FIR accused admitted his guilt before the villagers. It is not a fact that dead body was not recovered on being laid by the accused. There was no enmity between the accused and the deceased. The village meeting was attended by 50-60 people and the accused was asked to appear in the meeting on suspicion. The villagers made the accused to swear in the name of God, but he declined and rather admitted his guilt. It is not a fact that deceased died on his own. Next one is PW2, my lord,
Who's PW2?
page 10, my lord. In the year 2012, one Suresh Chandra Rabha went missing from our village. After 2-3 days, the family members of Suresh Chandra Rabha informed the villagers and they suspected the accused to be involved in the missing of Suresh Chandra Rabha. We called a village meeting and accused was called. The accused admitted in front of the villagers that he was killed Suresh Chandra Rabha because of previous enmity and he has buried the body near the mountain. The accused took the villagers to the mountain from where the dead body was recovered. In Cross, there were about 20-25 villagers at the time when accused admitted his guilt. It is not a fact that accused did not admit before us that he has murdered Suresh Chandra Rabha. It is not a fact that accused did not lead us to the dead body of Suresh Chandra Rabha. It is not a fact that I have deposed falsely. PW3 also,
Who's PW2?
2 is a villager, my lord, co-villager. Relationship is not depicted.
Okay.
PW3 also a villager, my lord, deposing in the same manner. In the year 2012, there was a village meeting in our village as the accused was suspected of committing murder of Suresh Chandra Rabha. In the meeting, the accused confessed before the villagers that he had killed Suresh Chandra Rabha because of previous enmity. It is not a fact that entire statement made by today in the examination in chief, never made by me in in the statement 161 of CRPC. It is not a fact that I have deposed falsely. It is not a fact that I was not present in the village meeting. Accused for PW4 page 12, my lord. She is the wife of deceased, my lord. I know the informant. I also know the accused. The deceased Suresh Rabha was my husband. The daughter of the accused was suffering from illness and the accused suspected my husband of practicing witchcraft. When my husband went missing, we kept searching for him but could not find him. Later, I suspected the accused and informed the matter to the villagers. The villagers held a meeting wherein the accused was called and he confessed before the villagers that he has murdered Suresh Rabha. I come from very poor family. After the death of Suresh Rabha, we have living our life in distress. In Cross, it is not a fact that I did not state in my statement under section 161 CRPC that the daughter of the accused was suffering from illness and accused suspected my husband of practicing witchcraft. It is not a fact that I did not state in my statement under section 161 CRPC that accused confessed to committing murder of Suresh Rabha in front of villagers. I had not filed any missing report in the police station after my husband went missing. Nagardi Prabha is the Gambura of our village. I do not know if accused used to mix with Suresh Rabha. I have personally not seen the accused killing my husband. PW5 is the son, my lord, of the deceased person. I know the accused. Suresh Rabha was my father. He went missing in the year 2012. we suspected that the accused might be involved in the missing of my father. We informed the matter to villagers. The villagers held a meeting, and in the meeting, accused confessed before the villagers that he had murdered Suresh Rava. Accused himself showed the place where the dead body of my father was buried. It is not a fact that I did not state in my statement under Section 161 CRPC that accused himself showed the place where the dead body of my father was buried. The village meeting was held 1 week after my father went missing. I have personally not seen the accused killing my father. It is not a fact that accused did not kill my father. Next, my lord, page 14 onwards, it is 131 statement of the accused, my lord, where in question number 2, 3, 4, 5, my lord, he has denied and he is not admitting the killing of Suresh Rava, my lord. In first answer to the first question, my lord, Sri Tirthanath Rava has deposed that in the year 2012, Suresh Chandra Rava went missing from our village. Do you know anything about it? He answered that I do not know how and in what manner Suresh Rava went missing. Answer question 2. PW1 has also deposed that after a few days he came to know that you have killed Suresh Rava. Do you have to say anything? It is not true. I have not killed Suresh Rava. Question number 3. PW1 has also deposed that village meeting was called in which you admitted that suspected Suresh Rava of the practicing witchcraft. Do you have to say anything? It is not true. Question 5. PW has also deposed that you admitted before him and other villages that you have murdered Suresh Rava in the mountain. Do you have to say anything? It is not true. I never admitted to killing Suresh Rava. The evidence is false. Number 5, PW1 has also deposed that you yourself led to the police team to the place where the dead body was buried and the dead body was recovered. Do you have to say anything? It is not true. I never led the police or villagers to any place. Next, question number 6 also, he is not admitting while he was asking about the deposition of PW2 that he did not kill Suresh Rava.
IO was not examined.
IO was not examined, my lord, in this matter, and conviction is based on entirely on the basis of extrajudicial confession, my lord.
He was not sent for postmortem.
FSL was sent for FSL and postmortem sent for, but reason of death in both the examination, no reason is being stated regarding the date, my lord, how it was took place and what are the weapons, what kind of injuries are there, and only basis of suspicion and his admitting statement before that village meeting, my lord, learned trial court has convicted, my lord, and his analysis of, my lord.
Before you come to that, let us see the postmortem.
My lord.
Page 37.
Page 37 is, my lord, postmortem report. Point number 2 is relating to wounds, my lord. Page 38, my lord. Body was found in a decomposed position, my lord. A partially skeletonized body is found in highly decomposed state with separation of bony joints. Soft tissues and organs are converted into a Flirtatious mass decomposed. 4 teeth are present in the mandible, 2 teeth on either half, first and second molar blatantly, literally, which are all stained. No teeth present in the upper jaw of the skull. Vertebral column is present up to L4 vertebra. No pelvic bone and circumfound missing. Right upper limb bones are present except right radius. Left upper limb bones are found missing. Both clavixes, sternum, all ribs, both scapula, left femur, bilateral tibia, fibula, left calcaneum are present. In the note, my lord, that left femur has been preserved and sent for DFS Kahilipara for chemical analysis, my lord, as no reason has been stated in the postmortem report regarding date, my lord. Page 41, one opinion is there, my lord. Opinion of the surgeon, my lord. Page 41. Opinion regarding cause of death kept pending till receipt of chemical analysis report from DFS Kahilipara. Thereafter, it was sent, my lord, and from forensic lab report, is it page 35, my lord. Page 35 is the report, my lord. On the basis of postmortem finding and chemical examination report of viscera, histopathological examination of the sample of tissues of deceased so-and-so, resident of so-and-so, Assam. I am of the opinion that cause of death could not be ascertained even after chemical analysis of bone at DFS Kahilipara. Please refer to viscera analysis report, histopathological examination report so-and-so, which read number so, poison was, no poison was found in the exhibit number so-and-so. So far as analysis of the learned judge is concerned, my lord, kindly turn to page 21, my lord, from para 16. Other in previous part that examination part was written, my lord. Paragraph 16, my lord, page 21. The investigating officer of this case could not be examined as it was reported that he was taken voluntary retirement due to illness. Since the death of Suresh Rava and the fact that death was homicidal is also not in dispute, the examination of medical officer was also dispensed with. The evidence produced above shows that this case is based on circumstantial evidence with two incriminating circumstances against the accused, namely extrajudicial confession and conduct of the accused in showing the place where the dead body was buried. It has been consistently laid down by the Honorable Supreme Court that where a case rests squarely on circumstantial evidence, the interference of guilt can be justified only when all the incriminating facts and circumstances are found to be incompatible with the innocence of the accused or the guilt of the other person, of any other person. The circumstances from which an inference as to the guilt of the accused is drawn have to be proved beyond reasonable doubt and have to be shown to be closely connected with the principal facts sought to be inferred from those circumstances. The case depends upon the conclusion drawn from circumstances. The cumulative effect of the circumstances must be such to negative the innocence of the accused and bring the offenses from beyond any reasonable doubt. That citations are there, my lord. So far as confession part is concerned, paragraph 19 analysis is there. Next page, my lord, page 22, 22, my lord. In so-and-so versus so-and-so, the Supreme Court has held that confessions may be divided into two classes, that is judicial and extrajudicial. Judicial confessions are those which are made before a magistrate or a court in the course of judicial proceedings. Extrajudicial confessions are those which are made by the party elsewhere than before a magistrate or court. Extrajudicial confessions are generally those that are made by the party or before a private individual, which includes even a judicial officer in his private capacity. As to extrajudicial confessions, two questions arise. Number one, were they made voluntary? Next one, are they true? As section 24 annex, a confession made by an accused person is irrelevant in criminal proceedings if the making of the confession appears to the court to have been caused by any inducement, threat, or promise, having reference to the charge against the accused person, proceeding from a person in authority, and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supporting that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceedings against him. It follows that a confession would be voluntary if it is made by the accused in a fit state of mind and it is not caused by any inducement, threat, or promise which has reference to the charge against him, proceeding from a person in authority. It would not be involuntary if the inducement does not have reference to the charge against the accused person, or it does not proceed from a person in authority, or it is not sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable or supporting that by making it he would gain any advantage or avoid any evil or of a temporal nature in reference to the proceedings against him. Whether or not the confession was voluntary would depend upon the facts and circumstances of each case, judged in the light of Section 24 of the Evidence Act. The law is clear that a confession cannot be used against an accused person unless the court is satisfied that it was voluntary, and at that stage, the question whether it is true or false does not arise. If the facts and circumstances surrounding the making of a confession appear to cast a doubt on the veracity or voluntariness of the confession, the court may refuse to act upon the confession even if it is admissible in evidence. One important question in regard to which the court has to be satisfied with is whether when the accused made the confession he was a free man or his movements were controlled by the police either by themselves or through some other agency employed by them or the purpose securing such a confession. The question whether a confession is voluntary or not is always a question of fact. All the factors and all the circumstances of the case, including the important factors of the time given for reflection, scope of the accused getting a feeling of threat, inducement, or promise, must be considered before deciding whether the court is satisfied that its opinion, the impression caused by the inducement, threat, or promise, if any, has been fully removed. A free and voluntary confession is deserving of the highest credit because it is presumed to flow from the highest sense of guilt. It has been further held in so and so that an extrajudicial confession is voluntary and true, made in a fit state of mind, can be relied upon by the court. The confession will have to be proved like any other fact. The value of evidence as to confession, like any other evidence, depends upon the veracity of the witness to whom it has been made. The value of the evidence as to the confession depends on the reliability of witness who gives the evidence. It is not open to any court to start with presumption that extrajudicial confession is a weak type of evidence. In the present case, para 22, my lord, in the present case, even though the evidences of PW3 and PW4 and PW5 that accused confessed to killing of Suresh Rabha suffer from material omission, which with respect to their statement under section 161 CRPC amounting to contradiction, yet the evidence of PW1 and PW2 do not suffer from any such contradictions. These witnesses have categorically deposed that accused admitted to his guilt and also showed the place where the dead body had been buried. The motive behind the killing was that accused believed the deceased to have been practicing witchcraft, a belief very strongly prevalent in this part of state. Now the question is whether extrajudicial confession suffered from any vices of vices as mentioned in section 24 Evidence Act, which renders it inadmissible. First, para 24, first of all, the admissions made by the accused was before his own co-villagers, as the evidence of PW 1 and 2 revealed that accused was summoned to attend the village meeting only on suspicion, and he was asked about Suresh Rabha. The accused, as deposed by PW 1 and PW 2, not only admitted that he made murdered Suresh Rabha, but also showed the place where the dead body was buried. The evidence of PW 1 and PW 2 and their cross-examination does not reveal that there was any threat or inducement on the part of villagers. In fact, it was open to the accused to deny any involvement with death of Suresh Rabha. The admissions made by accused was therefore made on his own motion and not under duress. Thus, the evidence on record does establish that the extrajudicial confession was voluntary. Coming to now the question as to whether the extrajudicial confession was true, PW1 and PW2 have deposed that in pursuant to the statement made by the accused and led by him, the police team reached the place where the dead body was buried. The knowledge of the accused regarding the place of burial of the dead body is relevant as post-crime conduct. In this regard, Section 8 of the Evidence Act provides that any fact is relevant which shows that constitutes a motive or preparation for any fact in issue or relevant fact. Explanation 1 to the Section 8 defines the meaning of word conduct and states that the word conduct in this section does not include statements unless those statements accompany and explain acts other than statements. But this explanation is not to affect the relevancy of statements under any other section of this act. The fact that dead body of Suresh Rabha was recovered in pursuant to the statement made by the accused is a relevant fact which explains his knowledge about the location where the dead body is buried. The burial place was in the mountains and was not known to any person until the discovery of such fact is pursuant to the statement made by the accused. The truth of the extrajudicial confession is thus explained by conduct of the accused is showing the place where the body of Suresh Rabha was buried. Thus, it is found that not only not only was the extrajudicial confession was voluntary, it was also true. Even though the accused in his examination under section 313 CRPC denied ever making any such statements before the villagers, but the evidence of PW1 and PW2 are found to be reliable, and hence the subsequent retraction by the accused becomes insignificant. Since the PW1 and PW2 are found to be reliable witnesses, the evidence tendered by them about extrajudicial confession is found to be reliable. These two witnesses are unbiased and not even remotely inimical to the accused. Further, there is nothing on record to suggest that PW1 and 2 have any motive of attributing an untruthful statement to the accused. The words spoken to by the witness are clear, unambiguous, and unmistakably convey that the accused is the perpetrator of the crime, and nothing in omitting by the witness which was milited against it. It is thus seen the prosecution has been able to establish the following circumstances against the accused: extrajudicial confession before the PW1 and PW2 that he had murdered Suresh Rava, that the accused believed the deceased to be practicing witchcraft is a circumstances which provides motive for the murder. The accused leading the villagers and the police team to the place where the dead body was recovered, which explains his post-mortem conduct. In the above three circumstances, rule out the possibility of any person involved in the murder of the deceased, and it is evident that, driven by his suspicion that deceased was practicing witchcraft, the accused put an end to the life of the deceased. The accused also concealed that the dead body in such a place where it would have been impossible for any person to trace the body, and it was only after 5 months of the date that the body was recovered in pursuant to the statement made by the accused. The prosecution has thus established that not only the accused committed murder of Suresh Rava but also concealed the dead body in the mountains. The accused is thus guilty of offense under section 302 IPC and section 201 IPC. And accordingly, the sentence part is page 28, life imprisonment with terms of 7 fine with fine, my lord. In this case, my lord, so far as evidence of PW 3 and 4 is concerned, my lord, 3, 4, 5, the 3, 8, 4, 5 already discarded by the learned trial court, my lord. And so far as 1 and 2 is concerned, my lord, in all along, they have stated about the admission of accused person in the village meeting. Nowhere it is stated where they are the attendee of that village meeting or not, before whom that accused was admitted about the murder, my lord, whether it was occurred by him or not. In their chief also, they has only stated about the admission that is made before the village meeting, my lord. So in that manner, they are though independently deposed, but their admission amounts to hearsay evidence, my lord, in my submission. And secondly, my lord, that medical report, FSL report doesn't disclose any date relating to the, my lord, date of the deceased person. So on the basis of extrajudicial confession and presumption, it is conviction is made, my lord. So whenever there are two views are there regarding accused in case of his involvement, my lord, that which view benefited the under benefit of doubt, which ultimately goes to the accused, my lord. So in my submission, my lord, I would like to submit that these evidence are, though there is contradictions and they are not that independent, that extrajudicial conferences are not directly made to them. So this finding is not correct, my lord, and it is based on presumption on the basis of evidence made by 1 and 2, my lord. So it has to be interfered with, and he maybe amounts to acquittal, my lord, as benefit of doubt is in his favor, my
When
lord.
was the dead body exhumed?
My lord,
When was the dead body exhumed?
it was found as per evidence after 5 months, my lord.
See, he disappeared after 1 week. FIR was lodged.
Yes,
correct?
my lord.
Then the meeting was held.
Meeting was held.
There he confessed to the killing of the thing.
Yes, my lord.
And it was only after 5 months that they went and recovered the body.
As per judgment in that, my lord, just now I have read, my lord. But other persons and what time it was recovered, in what manner they have come to that truth, there is no such description.
Judgment indicates 5 months.
5 months.
Postmortem indicates 4 to 5 months.
Yes, my lord. And
Lordship,
body was found in.
was done. Inquest was done.
Inquest was there.
Inquest was done, your lordship. An inquest report is the page 44, your lordship. Dead body found traced on 13/12/2012.
So far as section 24 is concerned, my lord, I'd like to
Where's
place.
the inquest report?
Page 44. Done.
13/12.
Yes. On the day FIR was lodged. your lordship.
Page 47, para 12, my lord, that opinion is there, my lord. Opinion of witnesses and police about the cause of death and weapons or instrument used thereof.
Page 40.
47, my lord. Serial paragraph 12. The decomposed dead body recovered from the jungle area in so-and-so part 2 under Kaziranga PS. This installed by the ex-magistrate in presence of which of locality. The body of deceased was murder case and the incident was occurred on 23/7/2012 as reported by the accused person who shown the place of dead body where digging.
(23/7).
My lord.
No, what this FIR was lodged after 1 week, isn't it?
Yes, my
After
lord.
you went missing.
Yes, my lord.
I don't get the connection.
It was filing date of FIR was 13/12/2012, my
After
lord.
5 months.
After 5 months, though it was stated as 1 week. Registration, Azaha registration date is, my lord, 13/12,
That's right.
2012.
That's right.
After 5 months, my lord. And neither the medical officer nor that forensic official are examined in this matter to prove the recovered body itself is that of the accused person. No such indication in any of the evidences, neither in medical or in other PWs also, my lord.
Okay. He went missing from 23/7.
Prior to that, no FIR was lodged, my lord.
No missing report of
No missing report is also reported. And so far as admission is concerned regarding that accused person, my lord, probably the village meeting where gathering of people is there. So for saving his life or some other extraneous other considerations also, he might be confessed, my lord. Whether it is willful or not, that he is admitted willfully and that person itself is the person whose body is recovered. No such thing was projected, my lord. Here only making one sentence in repeatedly in 1 and 2, my lord. That simple admission is there. What are the exact admission he has made before that persons, my lord, and whether they have heard it of their own or it is made before them, my lord, no such thing is mentioned in their evidence. So ultimately it leads to the hearsay evidence. Probably they might heard, they may not attend the village meeting also. It is not reflected in their evidences 1 and 2, my lord. As incident happened and contributing the factor that FIR is also late after laws after 5 months, my lord. So there is a late belated period. It is my lord registration. And one of the citation I would like to refer, my lord.
That's what.
Para 10, there is an
Nineteen eighty-five.
Supply 4 SCC 259. Para 4 and 10, my lord, I am relying. That circumstance, my lord. May I read, my lord?
Yes.
Facts are in a similar footing, but their dead body of two of the two daughters have been recovered from a pond, my lord, and it was also on the basis of extrajudicial confession, my lord. Para 4, it is stated, in a case based on circumstantial evidence, it is now well settled that the circumstance from which the conclusion of guilt is to be drawn should be fully proved, and those circumstances must be conclusive in nature to connect the accused with the crime. All the links in the chain of events must be established beyond a reasonable doubt, and the established circumstances should be consistent only with the hypothesis of the guilt of the accused and totally inconsistent with his innocence. In a case based on circumstantial evidence, the court has to be on its guard to avoid the danger of allowing suspicion to take the place of legal proof and has to be watchful to avoid the danger of being swayed by emotional considerations, whosoever strong they may be, to take the place of proof. It is in this context the above settled principles that we shall analyze the evidence laid by the prosecutions. Their prosecution theories are being analyzed, my lord, in this part. In para 10, my lord, one noting is there. An extrajudicial confession by its very nature is rather a weak type of evidence and requires appreciation with a great deal of care and caution. Where an extrajudicial confession is surrounded by suspicious circumstances, its credibility becomes doubtful and it loses its importance. The courts generally look for independent, reliable corroboration before placing any reliance upon an extrajudicial confession. So that part, my lord, suspicious circumstances. It is not free from suspicious circumstances, my lord. Doubt has been created, body has recovered, but their prosecution is not well enough to link the person with that particular incident, my lord. Neither IO nor that doctor is also stated in that manner, my lord. From the police authority who is investigating or assisting the investigation, no one is was deposed before the trial court, my lord. So it's only on the basis of presumption and that admission extrajudicial confession, my lord, that conviction is awarded, my lord. So it has to be interfered with in my submission. When two views are there, benefit of doubt always goes to the accused person, my lord, in absence of linkage of person.
Boyan, PW1 says FIR was lodged 1 week after the missing
Lordship,
of Suresh Chandra.
PW1, my lord.
In the process.
Yes, my lord. Even that PW3 also, that wife of the deceased, my lord, she also,
But the FIR next to the instant case, your lordship, nothing, the information received, my lord, at page 1, information received date 13/12, 11:30 AM. It's there. Lordship,
No,
after going in-
PW1,
yes, I
deposition
have
of-
found my lord, cross examination.
that contradiction part is also there, my lord, in 1 and 2, that in cross they have stated that there is no enmity between the accused and the deceased person, my lord. So if some kind of a enmity could have been projected, there might be, my lord, a ground for convicting him also, that only they have stated, one said 50-60 people attended the meeting, the other said 20-25 villagers attended meeting, my lord. So little contradictions are also there, and no one is stated. He has specifically mentioned regarding there is no such enmity for killing the, my lord, person concerned.
The motive is not enmity. The motive is that he was practicing witchcraft.
Witchcraft. But so far as three person deceased and the son, my lord, learned case court below has already discarded that their evidences, my lord. And the learned court only relying upon the evidences of 1 and 2, my lord, as I have already read down, my lord. So their evidences doesn't come into play, my lord.
Lordship, the case is based on extrajudicial confession and leading to discovery. Lordship, but there's lapses on the part of the prosecution, the trial court below, your lordship. Witnesses were not examined, official witnesses, MO, medical officer, IO, as per the version of the lordship, in the judgment it was observed, as he took voluntary retirement, that's why he was not called, your lordship, and he was ill, that's why also. And your lordship, the serologist, he was not examined. Your lordship, the medical officer was not examined. My lord, may I pray for end of justice, your lordship may send back the case for retrial, your lordship. May I refer one judgment of Jahira Habibullah Sheikh, base bakery case, your lordship. I have given the citation.
Which?
2004 SCC. 158. Para third, may I give the paragraphs? Para 30, 38, 39, 43, 44, 46, 47, 48, and 55. First, I take your lordship to paragraph 30, your lordship. Para 30. Page 182.
Yes.
Right from the inception of the judicial system, it has been accepted that discovery, vindication, and establishment of truth are the main purposes underlying existence of courts of justice. The operating principles for a fair trial permeate the common law in both civil and criminal contexts. Application of these principles involves a delicate judicial balancing of competing interests in a criminal trial. The interest of the accused and the public, and to a great extent that of the victim, have to be weighed, not losing the side of the public interest involved in the prosecution of persons who commit offenses. Then para 38, my lord. A criminal trial, as the lordship got it, para 38. A criminal trial.
Yes.
A criminal trial is a judicial examination of the issues in the case, and its purpose is to arrive at a judgment on an issue as to a fact or relevant facts, which may lead to the discovery of the fact at issue and obtain proof of such facts at which the prosecution and the accused have arrived by their pleadings. The controlling questions being the guilt or innocence of the accused. Since the object is to mete out the justice and to convict the guilty and protect the innocent, the trial should be a search for the truth and not a bout over technicalities, and must be conducted under such rules as will protect the innocent and punish the guilty. The proof of charge, which has to be beyond reasonable doubt, must depend upon judicial evaluation of the totality of the evidence, oral and circumstantial, and not by an isolated scrutiny. Then, my lord, para 39, failure to accord fair hearing either to the accused or the prosecution violates even minimum standards of due process of law. It is inherent in the concept of due process of law that condemnation should be rendered only after a trial in which the hearing is a real one, not sham or a mere farce and pretense. Since the fair hearing requires an opportunity to preserve the process, it may be vitiated and violated by an over-hasty, stage-managed, tailored, and partisan trial. Then, your lordship, para 43, my lord. As a lordship, okay. Para 43. The courts have to take a participatory role in a trial. They are not expected to be tape recorders to record whatever is being stated by the witnesses. Section 311 of the Code and Section 165 of the Evidence Act confer vast and wide powers on presiding officers of court to elicit all necessary materials by playing an active role in the evidence collecting process. They have to monitor the proceedings in aid of justice in a manner that something which is not relevant is not unnecessarily brought into record. Even if the prosecutor is remiss in some ways, it can control the proceedings effectively so that the ultimate objective, that is the truth, is arrived at. This becomes more necessary where the court has reasons to believe that the prosecuting agency or the prosecutor is not acting in the requisite manner. The court cannot afford to be wishfully or pretend to be blissfully ignorant or oblivious to such serious pitfalls or dereliction of duty on the part of the prosecuting agency. The prosecutor who does not act fairly and acts more like a counsel for the defense is a liability to a fair judicial system, and
Courts could not also play into the hands of such prosecuting agency, showing indifferent or adopting an attitude of total aloofness. Then your lordship, para 44. The power of the court under 165 of the Evidence Act is in a way of complementary to its power under section 311 of the code. The section consists of two parts. It is giving a discretion to the court to examine the witnesses at any stage. And then two, the mandatory portion which compels the court to examine a witness if his evidence appears to be essential to the just decisions of the court. Though the discretion given to the court is very wide, that very width requires a corresponding quotient. In Mohanlal versus Union of India, this court is observed while considering the scope and ambit of section 311 that the very uses of the word such as any court, any stage or any inquiry or trial or other proceeding, any person or any such person clearly spells out that the section is expressed in the widest possible terms and do not limit the discretion of the court in any way. However, as noted above, the very width requires a corresponding quotient that the discretionary power should be invoked as the exigency of justice require and exercised judicially with a circumstantial perfection and consistently with the provisions of this code. The second part of the section does not allow any discretion but obligates and binds the court to take necessary steps if the fresh evidence to be obtained is essential to the just decisions of the case, essential to an active and alert mind and not to one which is bent to abandon or abdicate. Object of the section is to enable the court to arrive at the truth irrespective of the fact that the prosecution or defense has failed to produce some evidence which is necessary for a just and proper disposal of the case. The power is exercised and the evidence is examined neither to help the prosecution nor the defense. If the court feels that there is necessity to act in terms of section 11, but only to subserve the cause of justice and public interest, it is done with an object of getting the evidence in aid of a just decision and to uphold the truth. Then your lordship, para 46, my lord. Ultimately, as noted above, the nauseam, the duty of the court is to arrive at the truth and subserve the end of justice. Section 311 of the code does not confer on any party any right to examine, cross-examine, and re-examine any witness. It is a power given to the court not to be merely exercised at the bidding of any one party, person, but the powers conferred and discretion vested are to prevent any irretrievably or immeasurable damage to the cause of society, public interest, and miscarriage of justice. Recourse may be had by courts to power under this section only for the purpose of discovering relevant facts or obtaining proper proof of such facts as are necessary to arrive at a just distance of this case. Then your lordship, para 47. Section 391 of the code is another salutary provision which clothes the court with the power to effectively decide an appeal. Though section 386 envisages the normal and ordinary manner and method of disposal of an appeal, yet it does not and cannot be said to exhaustively enumerate the modes by which alone the court can deal with an appeal. Section 391 is one such exception to the ordinary rule, and if the appellate court considers additional evidence to be necessary, the provisions in section 386 and section 391 have to be harmoniously considered to enable the appeal to be considered and disposed of also in the light of the additional evidence as per well. For this purpose, it is open to the appellate court to call for the further evidence before the appeal is disposed of. The appellate court can direct the taking up of further evidence in support of prosecution. In fortiori, it is open to the court to direct that the accused persons may also be given a chance of adducing further evidence. Section 391 is in the nature of an exception to the general rule, and the powers under it must be also be exercised with great care, especially on behalf of the prosecution, lest the admission of additional evidence for the prosecution operates in a manner prejudicial to the defense of the accused. The primary object of section 391 is the prevention of a guilty man's escape through some careless or ignorant proceedings before the court or vindication of an innocent person wrongfully accused. Where the court, through some carelessness or ignorance, has committed to record the circumstances essential to elucidation of truth, The exercise of powers under section 391 is desirable. Then your lordship, paragraph 48. The legislative intent in enacting section 391 appears to be the empowerment of the appellate court to see that justice is done between the prosecutor and the persons prosecuted. And if the appellate court finds that certain evidence is necessary in order to enable it to give a correct and proper finding, it would be justified in taking action under section 391. Then your lordship, para 55. The courts, at the expense of repetition, we may state, exist or doing justice to the persons who are affected. The trial, first appellate courts cannot be get swayed by abstract technicalities and close their eyes to factors which need to be positively probed and noticed. The court is not merely to act as a tape recorder recording evidence and overlooking the object of trial, that is to get the truth. It cannot be oblivious to the active role to be played for which there is not only ample scope but sufficient powers conferred under this code. It has a greater duty and responsibility, that is to render justice in a case where the role of the prosecuting agency itself is put in issue and is said to be hand in glove of the accused, parading a mock fight and making a mockery of the criminal justice administrative system. So I'm referring all these judgments, then as because there are lapses on the part, serious lapse, I mean to say, your lordship, on the part of the court below, your lordship, they have not called the witnesses were relevant to the issue. Even the officer who conducted inquest was not examined. The medical officer who did autopsy was not examined. The person, the serologist was not examined, your lordship. IO, who was, he said that he was ill, your lordship, and he took voluntary retirement. He was not examined. They are the relevant witnesses to prove the guilt against the accused person, right? At this stage also, your lordship may send back for retrial. An opportunity may also be given to the accused person for reducing defense evidence.
Yes. What do you say? We are this doctor in the serology.
Yes. Doctor,
Any
serologist,
attempts made by them, they could not come to any conclusion.
lordship. This because no, the doctor in his opinion has said, lordship, he is waiting for the opinion of the serologist.
The serologist report is something. else.
Negative, it's not. But the IO should have been examined, your lordship.
The magistrate.
Yes, my lord. Because he did the investigation part, my lord. Because main objective is to lordship to bring the entire evidence on record, whatever the witness have stated before the investigating officer. He has to like show it to the witness and lordship main purpose, my lord, to contradict whether he have stated before the police officer, whether he have seen, and he has to mark it, my lord, as per Tahsildar Singh's case, my lord, how the contradiction is to be proved. So he is a crucial witness, my lord. And your lordship, other part whether acquittal be granted to the accused person, that I leave it to your lordship for retrial if your lordship sends it back. ma'am. Benefit be given to the accused person. Because witnesses, they have deposed their extrajudicial confession made before him by the accused person, my lord. So like whether they have stated before the police officer about that fact.
What is there in the 161 statement?
Record to diog na? Record.
One witness has stated that the police also went, isn't it? The accused himself. PW1.
Lordship, may I? The statement of the complainant Trina Trabha. Lordship, he said, my lord, first I'll read it in vernacular, then I'll for Lordship's convenience, I'll translate it. মোৰ নাম আৰু ঠিকনা ওপৰত যোৱা ইংৰাজী 23/7/12 তাৰিখে মোৰ ভিনদেউ সুৰেশ চন্দ্ৰ ৰাভাই সন্ধিয়া ঘৰৰ পৰা গাঁৱলৈ ওলাই গৈ ঘূৰি নহাত মোৰ ঘৰটো বাইদেউ শ্ৰীমতী ধনমায়ে আহি জনাইছিল আৰু সেই বিষয়ে গাঁৱত দুবাৰ খেল মিটিং ভিনদেউৰ হেৰাই থকা বিষয়ে কোনে জানে এইভাবে অনুৰোধ কৰে যদিও কোনেও স্বীকাৰ নকৰে শেষত যোৱা ইংৰাজী 12/7/2012 তাৰিখে গাঁৱৰে দুখেশ্বৰ ৰাভা পিতা ৰাজেন্দ্ৰ ৰাভাই আমাৰ ৰাইজৰ আগত উপস্থিত থকা লোক মানে নগৰ সয়নসো আগত কৈছিল যে মই নিজেই সুৰেশ he himself admitted before the villager on 12/7 this দুখেশ্বৰ as per the statement of PW1 মই নিজেই সুৰেশ চন্দ্ৰ ৰাভাক হত্যা কৰিছো I have myself will kill সুৰেশ ৰাভা তেওঁ আগত কৈছিল যে দুয়োৰে মাজত আক্ষেপ আছিল সেইবাবে লাঠিৰে কোব মাৰি মৰিয়াই পেলাই প্ৰথমে তেওঁৰ মৃত্যু দেহাত লৈ জংঘলত লুকাই থৈছিল যদিও গাঁৱৰ ৰাইজে জংঘলত খোজ বিচাৰ কৰা দেখিয়ে মৃত্যু দেহাটো পাহাৰৰ এঢলীয়া নামনিত গাঁত খান্দি পুতি থোৱা বুলি কৈছিল he has confessed before the villagers that she had some previous enmity so first he beaten up the deceased beaten to death the deceased person he concealed the dead body in the village jungle my lord thereafter he concealed it in the hillock your lordship as the dead body the village people search for the dead body my
But so far as enmity part is concerned, my lord, in his deposition PW1, it is denied, my lord, in cross, specifically denied. It's not a suggestion.
Is there any recording that the police went and recovered the body?
yes Horrible handwriting, your lordship. I'm trying to read.
The villages where they choose to swear in the name of God. Cross.
In the statement of PW1, my lord, only one
Insist.
line is there, my lord. The accused himself led the police team to
that
place
is not-
where the
oh.
dead body was buried. But no such date, time, and what point of time it was recovered. It was not at all mentioned.
No,
Because
the
the
place that I have
IO
not found, my
was
lord.
not example.
Yes. It could have been better if the IO could have been examined, my lord, at that particular time, or his the assistant team, if he is not in position to depose, my lord.
Lordship, may I? Lordship, on 10/22, 23 to 2015. 23 to 2015, 10:39, 3 AM maybe, I don't. ATM of Hongdio staff.
Case diary.
I'll like it.
No, but it's in vernacular, no?
Vertical.
So there's no point
That's
flexing.
right.
it. You don't understand. You know how to read. Oh, my name.
Regarding whether it was exhumed, when it was exhumed. Lordship, to be proper, your lordship sends the case back to the trial court, my lord.
Then we'll have to set aside the judgment.
Because leading to discovery and extrajudicial confession, there are two parts. And daughter of the accused person, my lord, she has herself stated, daughter of the accused PW5, son, no daughter. Anibala Rasa. Accused confessed before the public. Accused showed the place, my lord.
Where?
PW5, my lord.
This line is very much clear, my lord.
Arina Bala Rabha.
We suspected that the accused might be involved.
I know the accused Suresh Rabha was my father. Or the daughter of the deceased, my lord.
This is the
Yes. Don't know money, Nike? Daughter of the deceased, I'm sorry, my lord.
Hmm?
Daughter of the deceased person.
It's not the son.
No. Accused himself showed the place where the dead body of my father was buried.
In cross, it is also stated, madam, the village meeting was held 1 week after my father went missing. I have personally not seen the accused killing my father. Whereas it's suspicion 45, my lord. Suspected that the accused might be involved in the missing of my father. On the presumption.
What's the meeting? Huh?
5 months.
Take down. Heard MS M. Burman, the amicus curiae. Also heard MS B. Buyan, then it's additional PP and some. For the year 4 respondent,
My lord, no private test.
for the state of Assam. So. Para. This appeal is directed against the judgment and order, judgment dated 4/10/2019, passed by the learned additional sessions judge within bracket FTC Kokracha in sessions case number 216/2017 under section 302/2201 IPC, whereby the appellant was convicted and sentenced to undergo rigorous imprisonment for life with further sentence of payment of rupees along with fine of rupees 10,000 and in default to suffer further imprisonment for 1 year under section 302 IPC. And also to undergo 7 years imprisonment with fine of rupees 5,000 and in default to suffer further imprisonment for 6 months under section 201 IPC. Stop. During the course of argument, New Para, and while appreciating the evidence, comma, we find that the PW1 PW1, who is the informant, stated that the accused oblique appellant himself led the police team to the place where the dead body was buried. Stop. Further, he stated that a village meeting was called in which the accused admitted that he suspected the deceased oblique Suresh Chandra Raba of practicing witchcraft. And accordingly, he had murdered him in the mountain. Stop. PW2 also states that the accused admitted in front of the villagers that he killed Suresh Chandra Babu because of previous enmity, and he had buried the body near the mountain. Stop. The same is the deposition of PW3, 4, and PW5. Stop. Surprisingly, we find that the IO of the case was not examined by the prosecution. Stop. Consideration of the evidence of PW1 would clearly indicate that the accused had led the police to the place where the dead body was buried. Stop. Thereafter, on recovery, post-mortem was held, inquest was held by the, where's the inquest report?
Inquest report is page 44.
Inquest report, inquest
Page 44, madam.
was performed by the
Executive magistrate, madam.
executive magistrate.
Parbat Chora Kajiga, page 48.
Barbot Jora Gadigal. Stop. Post-mortem was held, was conducted, and where was that FSL?
Page 43. Scientific officer, toxicology division, page 42, your lordship.
Page 35 is the opinion on official concern matter.
And chemical analysis was sent to the, what is DFS? Kahila Para,
Tahili Para, DF, Director of Forensic Science.
to the Director of Forensic Science, Kahila Para. Stop. We find that the medical officer who conducted the post-mortem, the person who conducted the FSL test, the FSL test, as well as the magistrate who performed the inquest were also not examined. Stop. Accordingly, we find that additional evidence is required for coming to a just conclusion, to see that justice is done between the persecutor and also the person persecuted against. Stop. in that view of the matter, comma, we direct the court of the learned additional sessions judge within bracket FTC, Kokraja, to take further evidence of the IO concerned, the medical officer, the executive magistrate who performed the inquest, and also the officer who performed the FSL test for coming to a just conclusion in the matter. Stop. Let such examination of witnesses as directed here and above be completed within a period of how long do you think it will take? 6 months?
3 months will do it.
That the IO is not,
Yes.
is gone on voluntary retirement.
Yes. ma'am. In absence of the IO, any person authorized, my lord, so that the duty is to like bring the case there and put it on record before his honorable court and to conduct the
Within a period of 3 months. 3 months will do from the date of receipt of the LCRs. Stop. Consequently, comma, the judgment dated 4/10/2019 passed by the Court of Additional Sessions Judge FTC Kokraja in Sessions Case number 216/2017 under Section 302/2001 IPC, 201 IPC is set aside. Stop. Registry is directed to forthwith remand to return the LCS, to send back the LCS to the Court of the Learned Additional Sessions Judge FTC Kokraja. Appeal, the present appeal is accordingly disposed of.
liberty may be granted to the trial judge also to
On top, you said, the appellant oblique accused may be also permitted to adduce evidence if he so desires.
Obliged.
need it, right?
Item 16.
I'll just put, we record our appreciation, no, to the learned amicus curiae for assisting this court. And she shall be entitled to fees
Right. It is decided by the legal services authority.
which shall be decided by the Assam State Legal
Legal.
Services Authority. Yes.
Lordship, this is a case, criminal appeal jail 60/2020. Here in this case, your lordship, the judgment have been passed by the trial court. It was a case of your lordship. Kasandas Kukrajar. And the judgment delivered on 3/12/2019, your lordship. From there, your lordship, the accused has filed in jail appeal. Accordingly, the case has been placed before his honorable court with all the papers. Here in this case, your lordship, the prosecution story is that, your lordship, there is a husband and wife quarreling each other, and the husband, by throw his axe, kill her neck. This is wife. And one eyewitness is there, that is the daughter. In this case.
Daughter was examined.
Yes, PW3. So this is the case. Accordingly, the public apprehended him, and thereafter he also confessed he was killed by under section 313 CRPC. That kill was not intentional due to the quarreling with each other under 313 CRPC, and he has been killed.
Let us see the 313.
Now, Lordship, they are about
Page 19,
Page
19.
19, Your Lordship. Page 20 is the last part. Take question number 10.
Repeated, my lord. Answer to question number 1, 2, 3, 4, 5, 6, 7, 8, and 10.
So
He admitted.
my straight away to question number 10. Do you want to say anything else, Your Lordship? So he replies as, yes, I do not want to kill my wife. There tussle between us, and suddenly the blow of the axe fall on the neck of my wife and sustained injury. On the basis of this statement, he was been charged under section 302, and thereafter prosecution established the case in the trial court, and he has been punishment for 302 under section. But so far the investigating officer is concerned. The investigating officer, the Lordship, that question, page number 18. Page number 18, Your Lordship. He said, there is an ask by the cross-examination, it is not a fact that the accused did not murder of his wife, and the charge sheet ought to have been filed under section 304. So, Your Lordship, if the ingredients of the 302 is concerned, so under section 300 IPC, one point is has to be established, that is motive. And here in this case, whether the motive has been established and to prosecute against the 302 IPC. Under the Supreme Court judgments in latest all the cases where there is a word of tussle, sudden provocation, heat, quarreling, this type of words comes under the fall of 304 part category. It may be part 1 or it may be part 2. But this case comes under the section 304 part 2. Because there is no predetermination of mind to kill on his own wife. The tussle between the husband and wife with one issue. Issue remains is that year. So wife want to come to his own matrimonial house. Husband pretend not to come. So in this between, they went from the house to one school, Francis school. There's one culvert took place, and this took place. It was in the dark, and in the meantime, the daughter also tried to dismantle their quarreling between the parties. But knowingly, unknowingly, the fight took place, and it comes in extreme position. The degree of intensity of the quarreling took place in such a manner that it was one kill. It was been, if you evaluate the section 313 CRPC, it has been categorically mentioned that yes, he has been killed. I have killed my wife, but that is not intentional. It has been killed. So entire prosecution story of this case, this comes under 304 part 2. Although it has been there. My humble prayer before this honorable court, Your Lordship, if I go to the evaluation of the PW1, that was the informant in the page 4, Your Lordship.
FIR.
FIR. I straight away go to the FIR. Page 4, with due respect, I would like to inform you that around 6:30 p.m., 7:30 p.m., Srimati Lohasi Brahma was axed to death by husband, Sri Tempa Brahma. The tragic incident occurred near the gate of St. Francis Xavier School, Dotoma. When the incident occurred, the daughter of the deceased mother saw the tragic murder by his father and Sri Tempa Brahma, anticipating in connection. And that way, accordingly, the Kukraja police station Dotoma police station outpost, registered the case under 302 IPC. Now, Your Lordship, again, page number 6.
Yes.
Now, Your Lordship, page 6. The charge has been framed. It has been mentioned, Your Lordship, that on 1/8/2018, that is on the first New Year, 6:30 to 7:30 PM, you committed murder by intentionally causing death of his wife, Lohasi Brahma, and thereby committed an offense under section 302 IPC with my cognizance. My humble prayer before this honorable court, the session just framed a charge against the person 3002 without considering the entire prosecution story of the case. Whether the frame charge against the accused person ought to be in 302 or ought to be in 304, that has to be determined before final conclusion of to frame charge against the accused person under section 302, Your Lordship. The Supreme Court judgment in latest also, it has been clearly mentioned. The trend of the prosecution will be start from the 302, from the framing of the charge is going in a stereotype way and come to the conclusion that it comes fall under the category of 302. That has to be discussed on this point of view. And that have been evaluated by the Supreme Court in 2022 latest judgment, Your Lordship. So my humble prayer before this honorable court, Your Lordship, then page number 7, the committed the CJM committed. Accordingly, Your Lordship, it is a session tribunal court and it has been transferred to session court. And he was jailed from 19/3/2018, page 7, Your Lordship. 19/3/2018, he was in the custody of jail Habil. Now, Your Lordship, if you evaluate the PW1, that is an informant. His name is Manik Brahma, Your Lordship. He said, I am the informant of this case. I know the accused. He belongs to our village. The incident took place 118 in the New Year day. On that day, all the persons were busy in celebrating the New Year. On that day, 5 to 6 PM in the Mission Road, the accused committed murder of his wife, inflicting injury with an axe, and after committing murder of his wife, he came to his own house along with an axe in his hand. When the public gathered and inquired the matter, then he confessed that he committed the murder of his wife. Thereafter, some of our villagers went to the police station and informed the matter. Police came, took the accused in their custody and lodged the FIR. Exhibit 1 is the FIR and Exhibit 1 is my signature. Police also seized the axe from the hand of the accused in my presence, and I also put my signature in the seizure list. So Exhibit 2 is the seizure list and Exhibit 2(1) is my signature. I have seen the material exhibit in the court. The material exhibit is the X. So this is the examination slip version of the informant. So he is also the seizure of the witnesses. Now in the cross, what he said, Your Lordship, in our village there are 116 numbers of houses of the families, and my house is in the trim line of the village. The Mission Road falls in the end of our village, which is about 1/2 to 2 kilometers far from our house. On the day of incident, I was in my house. I reached to the house of the accused at about 7 PM. When one villager informed me about the incident, the FIR was written in the police station. I have not read the FIR myself, but it was read over to me. I have not stated before the police that I saw the accused along with the accused. So this is the major part of their cross exam. It is not a fact that I have not visited a place of occurrence in the Mission Road. I have seen the accused in his own house, not in the place of occurrence. So it is not a fact that the accused did not kill his wife, and I lost the FIR on suspicion. At the time of the death, deceased was wearing dokhana and her dead body was lying in the side of the road nearby culvert. Generally at 6-7 PM, very few people goes by the road and it was dark. It was not the fact that the accused did not kill his wife, as he was in a drunken condition, villages under suspicion in the affair. So another point, he was in the intoxicated position in that relevant point of time, that the incident which have been occurred. Only one point I want to state, the PW1, who is an informant, he mentioned about that the time is 7 PM. But so far FIR is concerned, he write about the 6:30 to 7:30 PM. So there is one not a static position to confine the place of occurrence at what exactly time it was been occurred. And he even doesn't know the FIR, who has written it. According to someone has written the FIR, accordingly he has mentioned. So his FIR is also question of suspicion. The degree of the reliability is also been question mark, because he had to think all the things before, not place of occurrence, in the place of his house. That is the part. So my some humble submission is that he is not eyewitness of this case. That is my humble submission. Now, Your Lordship, PW2. He is a Kalendra Brahma. He writes He said, Your Lordship, before the court, I know the complainant and accused person. The incident took place on 1/18/2018. I came to know about the incident only on 7 p.m. At that time, I was in my house, and then the informant, Gambura, informed me that Tembra Brahmo killed his wife near Mission Road. During that period, I was working as a second village headman, and hence I went to the place of occurrence and saw the dead body of the wife of the accused, Tembra, lying on the side of the road. Thereafter, I informed about telephone and immediately rushed to the house of the accused. After discussion with other villagers, we informed the police. Accordingly, police came, took the dead body postmortem, and also take the custody of the accused. Police seized an axe from the hand of the accused. I put my signature. Scissor list Exhibit 2 and Exhibit 2 is my signature. I saw the material exhibit, but I cannot exactly say whether the material exhibit have been seen in the court was used by the court accused. So he's also not been confirmed about the material exhibit. So now, Your Lordship, again I came to the FIR. The cause, the date, the occurrence took place at 6:30 to 7:30 p.m. At that relevant point of time when the FIR was lost. Now he came to know after 7 p.m. Then the 7 p.m. And there is a contradiction in the PW1. He also said in the different time hour. So, Lordship, in the cross, my house is about 1 kilometer far from the place of occurrence. At about 6 p.m., the place of occurrence comes dark. It is not a fact that the accused did not kill his wife. FIR was only lost only on suspicion. When I met the accused, he was in drunken condition. I did not know whether the accused member had any mental problem. But once I heard that he jumped from the first floor of the APSU, All Boru Student Union, office at Dotma. It is not the fact that the accused is mentally ill person. We lost the FIR on suspicion. It is not the fact that the X was not recovered by the police from the house of the accused. Similar kind of X are available in the house of our community. So one thing is that is very clear here is how his mental condition has been narrated by the PW1 and PW2 in that case also. And they also said that the FIR which was lost, it is merely on suspicion. The most relevant part is, Your Lordship, the PW3, the daughter. I know the informant and the accused is my father and the deceased was my mother. The incident took place 1 year ago at 4 p.m. Now, it is another story that starts from the 4 p.m. On that day, my mother deceased came to my husband's house. And after 2-3 minutes of our arrival, my father accused also came to our house with an axe. Thereafter, he scolded my mother deceased and told her that why she came to our house and pushed her. Then he accused forcibly took her on the road. So he dragged on the road. When my father brought my mother to the road and was assaulting her, I tried to resist my father and told him that there is no need to scold her and beat my father and asked him to take her to his own house. But he did not listen to me, and hence out of fear, I tried to call another person of village. At that time, my daughter was also with me. When I went to call other villages, but I did not meet anyone near to place of occurrence. And then when I returned back, I saw my mother was lying on the side of the road in a pool of blood, and my father was standing near to her with an axe of his hand. Out of fear, I could not go near to my mother. Thereafter, my father went to his own house along with the axe blood sustained, and he locked himself inside the house. Thereafter, some other person also came near to my mother. Then I saw she sustained injury on the lower side of the neck of the right side. My mother was already died. Then the villagers informed the police station. So this is the examination of she. Now in prose, what she said, Your Lordship, the house of my father is 1 kilometer far from the place of occurrence. I used to come to my parents' house, and my parents also come to my house quite often on. My father used to tie the cow to my husband's house sometimes. My father used to bring and take back the cow. When the occurrence took place, it was dark. I visited inside the mission to call the person at the time of occurrence. The persons on the road by the wall of mission, it was a big wall. The teacher's room, hostel room were far from the gate of mission. If somebody inside the boundary of the mission cannot listen any noise from the road, When I returned back from the mission, my mother was standing near the body of my father was standing near the body of my mother. My father used to have alcohol. On the day of incident also, he was in drunken condition. Whenever he had overdose of alcohol, he could not control himself. We do not love our father accused. He used to have alcohol. My mother was wearing a pink dokhana and pink blouse at the time of her death. It is not a fact that my father did not kill my mother and he was in drunken condition while being the cow. Someone killed my mother and out of suspicion. The FIR was lodged against the accused my father. It is not a fact that I have not seen my father accused carrying the axe in his hand. So my humble submission in this case, Your Lordship, the cross-examination, whether the incident took place far away from the 1 kilometer from the place of occurrence, it is a case where the accused person want to tie his cow of the daughter's husband's house. So he used to come at the evening time. He used to take the cows to bring his place, and that till even point of time, the wife came to her matrimonial house, Your Lordship. In that matrimonial house, the quarrel took place not to come to her house. And that point of time, that there is a tussle between them, and there has been occurred. The sole witness of the daughter is to be trusty and reliability, because there is an enmity with her father prior to the place of cause of action on that day. She also admitted that she was in that relevant point of time in the intoxicated position. And the second point is that there is an enmity. The wife, mother, and the daughter did not love to her own father. So that is the version of the PW2. Your Lordship, PW3. PW4 is the VDP secretary, Your Lordship. He said that I know the complainant and accused person. The incident took place on 1/1/2018. On that day, I heard the accused Tembra Brahma committed murder of his wife with an axe. Thereafter, I also saw the dead body of his wife of the accused, and villagers informed police station. Police came and took the body of the deceased and also took the custody of the accused. The place of occurrence is 1 kilometer far from the house. I came to the house of the accused. I saw the gathering also. Police also visited the place of occurrence. I am a VDP secretary, so I have seen the accused in the house. It is not a fact that the accused did not kill his wife. We lodged FIR on suspicion. It is not the fact that we did not like the accused as he has some mental problem. So there is a 2 point comes. One is an intoxicated position, and another is the mental state of the accused person at that relevant point of time. Now we are also PW5. It is a doctor. Page 15, Your Lordship.
You read the last that cross. It is not a fact.
It is not the fact that accused did not kill his wife, and we lost FIR only on suspicion, Your Lordship.
Read together. Don't separate. Read separate.
It is not a fact that accused did not kill his wife, and we lost FIR only on suspicion.
Yes.
It is not a fact that we did not like the accused as he has some mental problem.
Yes. It doesn't mean that he did not like because he has a mental problem. That is what we are trying to read. Let us not read that.
That is the point, Your Lordship. His mental status and is not in an equilibrium position. When it
Do you mean to say that by this statement he said that he did not like because he has a mental problem?
there is one
It's
one
not
point.
that. It's the other way around. It is not a fact.
It is a suggestion, Your Lordship. It is a
Yes.
suggestion that it is a position that he is in a mental kind of
That's not correct.
mental position is there because he has suicide in the Apsu Dotama, in Apsu part, he fallen in the downstairs.
Let us not go into that. Let us go into this evidence. What he says is denying the suggestion
He denying the suggestion.
that he did not like the accused as he has some mental.
It is not a fact he
It's
did not
not a
like.
fact.
It is not a fact
In
that
other words, he said he likes the accused.
he like the accused and he has some mental problem.
No. Yes, he does not have any.
That is the person, Your Lordship. The cross-examination already been mentioned, and I just want to evaluate the point which have been raised right now. My point is that, dear Lordship, in this case, there's a 2 point comes out. One is the mental state. Consecutively, the PW1 to PW4, there is a raise of question of his mental part. Another part is the intoxicated part. Now, these 2 parts, if you combine each other, your Lordship, then it will become the position is equal to motive. Whether this mental and intoxicated is equal to motive will come in this prosecution of the case or not. That is the point, your Lordship. I want to try to place before this honorable court. Now, question PW5, your Lordship. It is a medical health expert of view on doctor. On 2/1/2018, I was on PM duty at RNB Civil Hospital, Kukrajar. On that day, one dead body of Rosai Brahma, female, 45 years old, was sent for postmortem examination. I have performed postmortem examination and found the following. There was a multiple incised wound and 3 major lacerated wound in the right side of the neck, cutting the major arteries and veining from 10 to 3x1 centimeter with tracy exposed 3x1x0 centimeter just above and below it. One lacerated found in the right leg. In my opinion, the cause of death is shock because of excessive blood loss due to the cut of major arteries and vein in the right side of the injuries. And injuries are in antemortem nation. Exhibit 3, postmortem, and exhibit 3.1 is my signature. In the cross, he said there was a possible of cutting injury if someone falls on a sharp object with a high input, but there cannot be a multiple injury by falling on one sharp object. She died out of excessively bleeding due to cut of major arteries of the neck. So major portion of the arteries, when it has been cut out, so she become unconscious and it will fall down in that. PW6, your Lordship. He is a village headman. I know the complainant. He is the village headman. I also know the accused, Temba Brahma, and this is Losai Brahma. The incident took place about 2 years ago. I heard that the accused Temba committed murder of his wife with an axe, but I had not seen the dead body of the deceased. I am working as a teacher at St. Francis School. An incident took place near the school. I have heard the accused committed murder of his wife, but I cannot say to what manner the wife of the accused died. Now, your Lordship, PW7, he is the investigating officer, your Lordship. He said, in the year 2018, I was discharging my duty as a OC of Dotma PS on 118 at about 10 p.m. I received an FIR from one Manik Brahma of Bongsi Horjara village. As part of FIR, one Tema Brahma committed murder of his wife with an axe and dead body was lying near St. Francis Xavier School, Dotama. After receiving the FIR, I immediately rushed to the place of occurrence, recovered the dead body, arrested the accused person from his own house along with his murdered weapon axe. Then I brought the dead body to the police station. On the next day morning, I inquest done by the magistrates. Thereafter, I sent the dead body for my postmortem. On the next day, I again visited the place of occurrence, recorded the statement of the witnesses, and subsequently I collected the medical report. The accused also handed over the axe by which he committed murder, which is accordingly 6. Exhibit 2 and Exhibit 2 is my signature. The accused also confessed his guilty before us while recording his statement. I have seen the material exhibit X in the court today. After the completion of investigation, I filed search sheet against the accused person under section 302. Exhibit 3 is the search sheet and Exhibit 301 is my signature. So my humble submission in this point, your Lordship, confession statement which have been done before the police, it should be corroborated and it should be in a proper procedural manner under the section the CRPC. Although he has been mentioned, your Lordship. I read in the cross Lordship, page 18. I registered the case of OC. Lordship. One Tema village committed murder of his wife with an axe and the dead body was lying near St. Francis Xavier School, Dotama. After receiving the FIR, I immediately rushed to the police of occurrence, recovered the dead body, arrest the accused person from whose own house, along with the murdered weapon X, and then I brought the dead body to the police station. On the next day morning, inquest was done by magistrate. Thereafter, I sent the dead body of the postmortem. On the next day, I again visited the place of occurrence, recorded his statement, the statement of the witness, and subsequently, I also collected a medical report. The accused was also handed over the acts by which he committed murder, which is accordingly Exhibit 2 and Exhibit 2(1), his signature. The accused also confessed his guilty before us while recording the statement. I have seen the material Exhibit 2(1) acts in the court today. After completion of the investigation, I filed a charge sheet against the accused person under Section 302. Exhibit 3 is the charge sheet and Exhibit 3(1) is the signature. Most important point here in the lordship, that there is no GD entry in this case. After receiving the informant, there is no mention in the GD entry. If you go to the FI also, we will not find the GD entry of this case. So on what basis the investigating officer went to the place of occurrence, immediately rushed to the place of occurrence, that has not been narrated in here. So my humble submission before this honorable court, the cross-examination, your lordship, what the investigating officer said, your lordship. I registered the case as OC of the PSI investigating the case on the basis of FIR through the GDNTV. The GDNTV was not mentioned in the FIR. That is the main vital part where the investigating officer failed to mention on his part. I prepared this case map of the place of occurrence. Near to the place of occurrence, there is a 145 shops, lordship. Please note, your lordship, there near the place of occurrence, there is a 4-5 shops, but while I was investigating the case, I did not find any of the shopkeepers to record their statements. On the next day, I meet the shop owners, but they told that they have not seen the occurrence and hence I did not record their statements. Very interestingly, there are not only 1, 2, there are 4 to 5. Assuming it is a dark side, assuming it is a lonely wall side, assuming it is a no one is there, still there is a 4 or 5 shops are there. Even if you trustworthy to the PW3 of the data of the prosecution of witness, she said about the other witnesses to call back to save her mother or place of occurrence. In that relevant point of time, investigating officer failed to record the statement on this case, your lordship. So there is a procedural lapse on the part of the investigation. That is my humble submission for this honorable court. Thereafter, your lordship, though the incident took place near to the school, I could not record the statement of any of the teacher or other persons of the school authority as they remained present inside the school campus and the gate was also closed. Please note, your lordship, in that relevant point of time, the hostel is there, school or persons are there. No, nothing, just stereotype investigation was done on the basis of the some of the villages and some of the part and done. If you lordship evaluate the prosecution witness, you will find there is no any independent witnesses from the other community of this case, your lordship. If it is in another community of this case, assuming from this, then it will be find that yes, there's something is occurred. The house of the daughter of the accused falls near to the place of occurrence. I recorded a statement, but I did not record the statement of her husband. He was not present at that time of this incident. I have not sent the ex murder open for examination to FSL. Though the accused confessed his guilty before us, I did not send the accused to record his confession statement from magistrate. I did not send the accused to record his confession statement from magistrate, your lordship. The inquest was done by the election officer, Asim Borgohai. It is not the fact that accused did not murder of his wife and a charge sheet ought to have been filed under section, your lordship, 304 of the IPC against the accused person. It is not a fact that I did not file a charge sheet on proper investigation of the proper consultation of the postmortem report. So this is the investigation part of the IO where he has not recorded a confession statement. If you treat it as a confession statement as a piece of evidence also, dear lordship, there is no any procedure have been done by the prosecution. And moreover, without GD entry on the basis of FIR, the FIR has been done at 10 p.m. your lordship. The incident took place at 6:30 to 7:30 p.m. The FIR has been date of receipt and information at 10 p.m. At that relevant point of time, 6:30 to 7:30 to 10 p.m. within 3 hours. The investigating officer rushed to the place of occurrence without entry to GD entry. So it is a totally collapse on the part of the investigation. And moreover, your lordship, the place of occurrence, the sketch map which have been shown here, your lordship. The dead body was fallen in some another places. After murdered by the accused person, that has been kept in another places, in the one jungle or in the bush. But these things ought to have mentioned before the exemption sheet. And there is no any tally, there is no any corroboration with the sketch map and the statement placed before this honorable court, your lordship. There is a contradiction if you lordship find the sketch map also. And moreover, your lordship, the another thing, the circumstantial evidence goes to the 5 golden principles as hard binding principles. It has been already been discussed by learned counsels in the amicus curiae matters. So it is there in the judgment. So there must be subsequent event should be there. There should not be any kind of any gap. Here in this case, one missing link is that assuming the PW3 is your lordship, PW3 is the data is treated to be trustworthy also. In another part, she said that there is no any person except only the school friend. But the investigating officer, your lordship, in the shopkeepers are ought to be assuming 1, 2, 3, 4, 5 shopkeepers are there, 4 to 5 shopkeepers. They have been seen. So the gist of the case, entire it has been the mere suspicion, your lordship. It is a fact of this case, your lordship. If your lordship permit me to go to the Tritani statement, these are the statements, a monotonous statement. There's nothing in itself. If you ask me any question, you'll say, yes, I have murdered, yes, no, this is the question. But when you say voluntarily to any ask, if you want to say something, then his inherent talents, inherent voice comes out in the question number 10, and that is the answer, your lordship. I do not want to kill my mother. The tussle between us, suddenly the blow of the axe fall on the neck of my wife and sustain injury, your lordship. Now, the prosecution ought to have asked me that there's a multiple injuries on the part that there is the intention of your killing, your lordship. That may be another subsequent question, or maybe question mark. But my humble submission is that, your lordship, since I continuously resisted to not to come to my house in that 11 point of time, she pushed come back to here. And assuming, your lordship, if I want to do any kind of occurrence, if I want to do any intention, I ought to kill him in my home itself, not to go to the 1 kilometer far away. And in PW2's statement, if your lordship permit me, in that 11 point of time, in the statement which have been placed before here, your lordship, is not in a continuous mode. May I read again the PW3, your lordship? Page 12, your lordship. The daughter. I know the informant and the accused is my father and the deceased was my mother. The incident took place 1 year ago at 4 p.m. On that day, my mother deceased came to my husband's house. After 2-3 minutes of her arrival, your lordship, my father accused also came to our house with an axe. Thereafter, he scolded my mother and told me her that she has to come to our house and push her. And then he accused forcibly took her on the road. When my father brought my mother to the road, and was assaulting her. I tried to resist my father and told him that there is no need to scold and beat my mother and asked him to take her to his own house. But he did not listen to me, and hence out of fear, I called to another person of village. And at that time, my daughter was also with me. When I went to the call other villages, but I did not see meet anywhere near to the place of occurrence. Then when I returned back, I saw my mother was lying on the side of the road in the pool of blood, and my father was standing near to her with an axe of his hand. So it is, if I pause on this sentence, your lordship, it means she has also not seen the cause of action. But she has also not mentioned, she has not also seen the case, the way it has been happened. That is why, your lordship, if lordship permit me, the page 27 of the judgment by the paragraph 18, your lordship, the trial court said, your lordship, page 27, your lordship, paragraph 18. May I read the relevant part on the evaluation of the PW3, what they say. So the vital witness of the entire prosecution case is PW3, who was present at the time of incident. It is admitted that PW3 has not seen when the accused inflicted injuries on the neck of her mother with an axe as she was running towards Mission School to inform the matter to other persons. But while she was returning to the place of occurrence, she saw her mother was lying on the ground with severe cut injuries on her neck, and her father accused was standing near to her mother. with blood-stained axe in his hands. Out of fear, she could not near to her mother, but after getting up some people, she came to near her mother and saw that there is a deep cut injuries on the lower side of the neck. In the right side, and their ocular evidence in the respect of injuries fully support of the medicals of the doctor. From the cross-examination, it is seen that she had visited inside the. From her cross evidence, it is seen that she visited inside the mission to call the person, but no one could be seen as the wall of mission is very big wall and research room, hostel are very far away from the mission. Thus, the entire circumstances of the case pointed towards the PW3 of the towards the accused. So these are the principles, Your Lordship, in paragraph 19. If you rely the trustworthy of the PW3 also, Your Lordship, there are lots of other persons are there. When I cut a person to in a deceased person, there must be reaction will comes out. Reaction will comes out, Your Lordship. But this is a case where only on the basis of the PW3 that at the time of accident, dead body with axe, blood stain, that is one point. Another point, in 313 statement by the accused person, he himself that is voluntarily confessed that yes, there is a tussle between them. Now, the tussle, the meaning of tussle here in this case, meanings of intoxicated mental state, and another part is the, Your Lordship, his psychological state of mindset. So, my humble submission before this honorable court that this is not a case of 302. If I killed at that 11 point of time, not beating, assaulting from towards coming from the outside from the road to from home to a road, then ought to have killed by accident that 11 point of time. But at the, initially, I beat, as per the version of the PW3, I beat her. Thereafter, it's happened. But entire positions in the story, if Lordship permit there, is a mere suspicion. Now, circumstantial evidence. The 5 circumstantial principles or golden principles says that there must be continuous, spontaneous, consequent, subsequent, one after another. And if you see the missing link, Your Lordship, the FSL report of the investigating officer, if it corroborates the blood stain which the action has been done by the X, the same blood of the person who has done these things, then it will be considered. And here the multiple injuries are there. Now, if I considered myself that there is a tussle between me also, that multiple injuries maybe because in the PW3 in her statement, when he become out of control, he can do everything. Now, when my mind is not a static mind, Your Lordship, then definitely there should not be any kind of predetermination of mind to kill my wife, assuming in for a time being also. So it is a case of it's a general phenomenon in Indian society that there's a tussle between the husband and wife took place, and thereafter what is happened, Your Lordship, is happened out of anxiety, out of fearness, out of angerness, this is a degree of high intensity. When a person hurt to some in some definite things, Your Lordship, definitely the anxiety comes out, and that may not be think about the cause of death. So this is the cases happen here, I would say. So, Lordship, I place one judgment. It is a very written judgment, latest judgment. Criminal Appeal Jail 27/2017. It is 16/12/2022. I am only, Lordship, I want to place this. It is a judgment Rajumra versus State of Assam. I beg to apologize. I have only one paper, sir. I placed 3 judgments. Is a
Are those
Supreme Court judgment.
separate judgments?
Paper, yes.
You make copies and bring it. It's difficult to share, no? Very difficult to share.
I place I had placed only one copy. If Lordship permit me,
We'll take it up on Monday. You make copies and.
Lordship will remain as, this matter remain as partner. I'll do my part on that day.
Yeah. Heard Mr. B.N. Gogoi, Leonard Amicus Curiae. Also heard MS B. Boyan, Leonard Edition PPS. Heard it not. This 4:40. Monday we'll get some, fix some matters, no?
Yes, part third, that part third matter where we are to give only written submission. This has come out, you know. This is-
31st will be, 31st.
Deeply obliged. Lordship.
Please, your lordship. Lordship, in this matter, we have not received the paper book, lordship.
I have received that one.
You have not received.
Yes, lordship. As per instruction of my senior lordship, he said that he has not received.
Perhaps the paper book is lying in the.
Is there extra paper book?
LCR or something else. There is the LCR. Perhaps this is meant for the app.
One paper book is there extra?
Yes. Yes.
Can we just hand it over now or later we just to hand it over?
He can take our signature and have it over.
Your good name, please?
K. Bora.
MSK Bora, Leonard Council appearing on behalf of
I Chaudhary.
I Chowdhury, Leonard Council for the appellant, submits that they are yet to receive the paper book. Stop. She is directed to furnish a copy of the paper book to the Learned Council for the appellant. Stop. Also heard MS is done and an additional PPS. List the matter again after 1 week, 2 weeks,
As per your convenience.
2 weeks.
What about
Oh, yes, that written argument, I'll positively submit it on Monday morning. And if your lordship requires, I can mail it also.
we thought of missing it today.
Acha, by afternoon, I'll mail it.
The other one, the Americans or
Other,
appellant?
he has also not, I mean, he said,
And they inform him
he'll also mail it if by evening.
by Monday.
Monday you submit.
Otherwise, by evening, I can mail if your lordship is writing. I couldn't really get time yesterday, so I'm so sorry.
She put it in the other case. That's part of it.
Oh, wait, 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 wait.
Monday, morning was the-
Written submission. Hey, back to the media.
written submit. So it will not take long.
No, no, yeah.
Monday, serious.
So the day kita lalu. Kami mau sudah kuliah.
Delay হৈছে এইটো মণি আৰু এইটোৰ ৰাজেন সিং কোৱা নাই ন লিম্বু তোমাৰ ৰাজেশ পৰাই এইটো মই উলিয়াব আৰু ৰাজেন সিং উলিয়াব বুজিছ তই এইকেইটা লৈ যাম দুটা মই তিনটা হ'ল তাৰ আৰু বাকী থাকিল দুটা মই ল'ম
Tomato.
আমার ভালো ছিল শুধু 5 দিন মোবাইল আছে কখনো ধরনের মোবাইল আছে
এনেকে চাই
আর বহুত তিনি ভালো আসলে যে একটা পার আছে কখনো সেগাস না না ফেসবুক না সব একটা যেমন ভালো করে রেফারেন্স আর না মনে আপনার এডিশন আছে